Say, man, you got a joint?
No, not on me, man.
It'd be a lot cooler if you did. All right.
What you just saw was a scene from one of the best movies of the 1990s, perhaps all time, Dazed and Confused, starring Matthew McConaughey, Ben Affleck, and a lot of other people who went on to have very successful careers in film. My name is Dan Batari. I'm a personal injury lawyer in South Florida. And in this particular scene, what you're seeing 3 or 4 of the students celebrating the last day of school. It's 1976. It's Texas. It's summertime. And they're doing what a lot of teenagers do on the last day of school, and that's by partying and having a little bit too much fun. In this scene, you see 3 or 4 of them picking up trash cans and throwing them at mailboxes. One of them even goes so far as to throw a bowling ball into the back of a car. And one of the homeowners tracks them down when they're getting beer at a convenience store, pulls a gun out on them, and says that they've violated federal law. And what I wanted to know is, and I wanted to let you all know, that what they did was absolutely a federal crime. And that's because under 18 U.S. Code 1705, destruction of letterboxes or mail, it is a federal offense to damage mailboxes. And it is punishable by up to 3 years in prison and by up to a $250,000 fine. In Florida, if they were to do this in Florida, that would be criminal mischief. Criminal mischief is vandalism. That is the common term for criminal mischief. A lot of people think of vandalism as graffiti, just as overall damage. So what they did was criminal mischief. And the question then becomes whether or not it was a misdemeanor or a felony. The severity of a criminal mischief charge will depend on the value of the property damaged. So in this particular situation, you have mailboxes. So if the mailbox was valued between $200 and $1,000, that's a first-degree misdemeanor punishable by up to 1 year in jail. If the mailboxes were valued over $1,000, or if they were used for business purposes by them disrupting the business, that's a third-degree felony punishable by up to 5 years in prison. So I think, especially because this was 1976, the value of the mailbox is probably, relatively low, relatively cheap, especially cheaper than today's standards. I would say that they committed a second-degree misdemeanor under Florida law, because then the value of the mailboxes would be less than $200. But they absolutely committed a federal crime because they damaged mailboxes, and you can't do that. Then we want to know whether or not the old man who stopped them was legally justified in pulling out a gun. And like I said, there are certain instances in Texas when somebody can use lethal force if they reasonably believe that it is necessary to stop the commission of imminent criminal mischief. And even if that were the case, where the old man could do that, I would highly advise against that. And that's because whenever you see the word reasonable in a statute, what that means is that you're leaving the interpretation of the facts up to a judge or a jury. And that means you're putting your life in their hands. You don't want to be in a situation where you're subject to somebody else making a decision over your life. I don't know whether or not what he did was reasonable. That's up to a jury, or it's up to a judge to decide, depending on the type of motion filed by the criminal defense lawyer. So what I really wanted you all to get out of this is that whenever you see the word reasonable in a statute, just know that that's how a lot of attorneys make money. Attorneys make money litigating whether or not something is reasonable or not. And a lot of times, trials or plea bargains, I should say, are made due to the uncertainty of a jury trial outcome. Nobody knows how a jury is going to decide. And a lot of times what happens is that a defendant in a criminal case or a plaintiff or a defendant in a civil case is going to have to weigh the risk of going to trial and losing against the potential reward for winning. So for example, if a prosecutor offers a defendant a plea bargain to 10 days in jail on a first-degree misdemeanor. Now, first-degree misdemeanors are punishable by up to 1 year in jail. If they offer them 10 days in jail, let's say the person says no. If the person says no and they go to trial and lose, well, then the judge can legally sentence them to up to 1 year in jail. So a person has to weigh whether or not it's worth it for them to risk 354 days of life by going to trial and losing, and only they can make that decision. When you're talking about trials, and you're talking about especially criminal trials, you're really dealing in the world of high stakes gambling with liberty. It's not money. You're gambling with your liberty.
But they'll never take our freedom!
So if you're going to trial, you really want to make sure that it's worth it to you, that it's going to be worth it for you to potentially lose the case and get substantially more time than you would if you had accepted a plea bargain.
Accept your plea. You will give up your right to appeal along with all other rights I've enumerated. Do you understand?
Yes, sir.
State attorney going to be able to prove beyond a reasonable doubt that either of them committed criminal mischief. Remember that it's the state attorney's burden of proof. The defendant has to prove nothing. The state attorney has to prove everything. They have to bring forth the evidence to convince a jury beyond a reasonable doubt that a crime occurred. So to prove criminal mischief in Florida, the state attorney is going to have to prove 4 things happened beyond a reasonable doubt. 1, they're going to have to show that the property was damaged. I think they're going to be able to do that because they'll be able to bring in the angry homeowner to testify that his mailbox was blown up. They're going to have to show that the property that was damaged belonged to someone. Again, he'll come into court, he'll say my mailbox was damaged. 3, they're going to have to show that the damage was done both willfully and maliciously. And if they believe that it was the defendants who did it, I think they'd be able to prove that. Why else would somebody do that to a mailbox if it wasn't willful or malicious? And 4, they're going to have to show the amount of the damage done to the mailbox, especially if they want a felony conviction. So to support a felony conviction, the state attorney will have to prove beyond a reasonable doubt that the damage to the mailbox was over $1,000. Again, this is in the 1970s, so I'm not sure what that amount would have been then, but in current times, that's the standard. I don't think they're going to be able to prove this because the biggest issue in this case is they're not going to have enough evidence that it was any of them in the car who did it. The angry homeowner seemed like he was guessing. He was more asking them if they did it rather than asserting that they did it. And it's 1976. They don't have any photographs. There's no video. It's nighttime. So absent a confession from anybody in the car, I don't think the state attorney would have enough evidence to prove beyond a reasonable doubt that anybody in that car committed criminal mischief. I think they're walking free.
All right, all right, all right.
You know, I always loved this movie, Dazed and Confused, because I always thought the actors did a really good job of expressing the feeling, conveying what it's like to be a teenager, going through the range of emotions that teenagers experience, even some of the existential issues that you see from that intellectual crowd, what they're going to do with their lives and, finding meaning in your life, those types of things. So I always thought the actors did a really good job of that. I always thought that the 1970s and the 1960s were a special time to live. Things just seemed a lot more simple back then. So I want to know if any of you feel that way, if any of you feel that you were born in the wrong decade, if perhaps you would have enjoyed living at a different time period, and if so, what that time period would have been. For me, it would have been the 60s and 70s. I think I would have really enjoyed the music, the classic rock, the cars, really everything except the Vietnam War. I mean, that was terrible. But besides that, life seemed pretty good. Also, the characters in the film. You had O'Banion, who was that asshole who really took enjoyment on beating up the kids who were going from 8th grade to 9th grade. For whatever reason, took enjoyment in that. It seems like every high school has one of those guys. I know mine did. And then you had Randall Pink Floyd, who is the main character, the protagonist of the film, who had this really anti-authority, anti-establishment type of attitude, where even though he was the athlete, he was still able to get along with all of the different crowds. He was friends with the intellectual crowd. He was, friends with all the girls. He really just seemed to get along with everybody. He really even, was really kind of an individual. He was the maverick of the group. He stood up against his football coach when the football coach said, "Hey, sign this pledge sheet." The pledge sheet said, "I agree to not engage or participate in the use of drugs or alcohol during the football season." And he said, "No." He said, "I want to play football, but not on those terms, so I'm not going to do it." You had Wooderson, who kind of refused to grow up. He was in his 20s, still hanging out with the high school kids, just wanting to have a good time, keep a little change in his pocket. All right, all that fun stuff. So, great movie. I'll probably do more on it in the future. If you like this